Morning, everybody. My name is Bob Lusick. I am the chair of the litigation department at Sheehan, Finney, Bass and Green, and I am also the incoming chair of the environmental practice group of an organization called Lex Mundi. Sheehan Finney is a member of Lex Mundi, and as part of my job as both an attorney and as the chair of the Lex Mundi environmental practice group, I have been spending a lot of time over the last several years thinking about stormwater. And it's particularly important right now in light of what's been happening in New Hampshire and also in Massachusetts with respect to stormwater. As anybody who's heard me talk about this stuff before will know, stormwater is subject to the Clean Water Act. Essentially, the Clean Water Act is a law that relates to and regulates discharges into waters of the United States. So, lakes, rivers, streams, estuaries, the ocean, all those areas are regulated by the Clean Water Act. And one of the major sources that discharge into the waters of the United States is stormwater. So, big storm here in the Northeast, we have nor'easters come through. Storm runs off of roads, through culverts, off people's lawns, into rivers and streams, and frequently those discharges, that runoff, contains pollutants, contaminants that are problematic for people. So, why is this important now? On January 23rd, 2017, the US EPA here in Region 1 in Boston issued a new stormwater permit for New Hampshire for what are called MS4s. MS4 is just a designation that the government gives to areas that have a certain level of urban density. The MS4 communities in New Hampshire basically are most of the southern half of the state. Most of the people of New Hampshire live in one of the MS4 communities that are affected by this stormwater permit. The basic way this process works is the Clean Water Act gives responsibility to the state of New Hampshire to do certain things, and then based on a wrinkle in the program, US EPA, the federal government, actually issues the permits for New Hampshire and Massachusetts. New Hampshire and Massachusetts are only 2 of 4 states in the country where this is the case. In most of the rest of the country, in 46 other states, the state itself issues the permits and is the regulating authority. New Hampshire still has a great deal of responsibility with respect to these permits, because under the Clean Water Act, New Hampshire, each state, New Hampshire in this instance, is required to set the water quality standards that are part of how one determines what needs to be done under the Clean Water Act. So they set the standards, they determine how clean, or what is clean and what is not. And in that regard, every 2 years, the state of New Hampshire is supposed to essentially evaluate the rivers and streams and estuaries in the state and create what is called the Impaired Waters List. For people who practice in the area, it's called the 303D list. And that list is very important because that is the state's determination of what waters are impaired in the state of New Hampshire. And from that, US EPA then writes permits for wastewater treatment facilities, for factories, but also now writes it for stormwater discharges. And the permit that has been issued is now that was posted on the website. This is the permit. It is 260 pages long. It is one of the most stringent permits in the United States. The other stringent permit is Massachusetts, which was issued earlier in 2016. The effective date of this permit is July 1, 2018. So, in theory, there are 18 months before this becomes effective. The fact is there is a lot that needs to be done, and there are very detailed requirements as to what the cities and towns who are affected by this permit are going to have to do, and the cities and towns simply aren't going to be able to wait until July 1st, 2018 to start doing stuff. They're going to have to start doing stuff relatively soon. As I said, it's 260 pages long. Maine, which does its own permits, has a stormwater permit that's 29 pages long. It is much less stringent and onerous than New Hampshire's and Massachusetts. There are lots of issues that are problematic in this permit, and that are going to cause cities and towns to expend an enormous amount of money to comply with the requirements of the permit. But one of the things that we look at are, has EPA in this context followed its own rules? Has it followed its own regulations in issuing the permit? And without going into the details of all of the issues that are related into the permit, there are a couple that are really, really critical that we need to think about. The first is that EPA has included in this permit language that says that if a municipality, if a community, if stormwater discharges cause or contribute to an impairment, then it has to be dealt with, and they have 60 days to deal with that problem. That language is very troubling. It is not contained in the EPA's regulations, and it essentially changes the burden onto the communities to require them to make the determinations as to the discharges they are making into the quote-unquote impaired waters, and presumes that those discharges are negatively impacting the impaired waters. So it essentially is taking the requirement away that EPA make that determination itself and say, this is a problem, you have to deal with this. What this provision does is it presumes that the municipality is causing the problem. And it puts the community at great risk. First of all, as I said, the compliance time is very, very short, and the resources that are going to need to be expended to address it are going to be difficult for communities to come up with. The other aspect is that obviously if you don't comply, you're subject to fines and determinations from EPA, but also subject to citizen suits. So lawsuits brought by environmental organizations or citizens in the community to prevent the discharge from continuing. So that places a very onerous burden onto communities. The other aspect, and there are many, the other aspect of this that is particularly troubling in our view is there is a provision in the new permit that essentially prevents or slows down any new development in a community. It's contained in what's called an anti-degradation provision, and it essentially says that any increase in discharge into an impaired water has to be approved by the agency. So if you think about that, if you think about how that is going to affect developers, people wanting to bring businesses in, anything that is going to add to increase a discharge, a new parking lot, a large roof. Those kinds of things are going to add to the discharges into the waters of the United States, and therefore need to be approved by EPA. So that language really is adds a layer of regulatory oversight onto communities that is going to slow down, if not stop, development in that community. So on the one hand, this permit obviously requires an enormous amount of time, effort, money to comply with the provisions, but it also prevents communities from increasing their tax base because it is going to hinder development. So those two provisions alone are very problematic, and it is essentially a permit in our view that is going to be nearly impossible to ever actually comply with. The provisions of this are going to make life very difficult. So what needs to happen? Any community that is affected by this permit, if they do not appeal the permit, then they will be deemed to have accepted the permit. And if you've accepted the permit, even if there are provisions in this permit that are contrary to the regulatory authority of the agency, if you've accepted the permit, you're bound by it. The courts view this like a contract. So if you've accepted it, you've got to deal with it, and you're going to be subject to all the provisions. You can't go back later on and say, wait a minute, you didn't have the authority to make me do this in the first place. The time to raise those issues were in the comment period prior to this and during the appeal period that is beginning to run. So if you are concerned about this, if you think that there are issues that relate to your community, if you feel that there are things that you need to understand and address, we have been working with a number of New Hampshire cities and towns, a coalition of communities that are affected by this. So you should feel free to contact us, contact me directly. And I can put you in touch with the parties that are involved in this. My direct dial is 603-627-8188. You can call me if you have questions or concerns about this. One thing I am obligated to say as part of this program is that this does not constitute legal advice. This is my take on this program. So if you'd like to discuss this further with me or any of my colleagues, or discuss it with your own counsel, you should do that. This is my take on it. Obviously, there's a lot in here. There's a lot to read, and there's a lot to understand. It's complicated, but we've looked at just a couple of highlights here today, and we're happy to go into any other issues that you think would be helpful for you to understand. Thanks very much.